Losing a loved one is never easy, and no matter how hard you try to prepare for it, it's still devastating when it happens. But even more devastating is to not have plans and tools in place to take you through the process when that time comes. When I say tools and plans, one plan in particular I'm talking about is an estate plan. There are many tools in a plan, estate plan, that you need to have, but there are three in particular that must be in the plan to ensure that the process is easy for the family when it happens. Before I get into those three things, please click and subscribe to this channel and also press like. Share this channel with those who you know will benefit from the information in this video as well as channel. So the three things that a person needs to make sure that is in their estate plan is a will, power of attorney, and a healthcare directive. Another word for healthcare directive, by the way, is living will. So what is a will? A will basically is a signed legal document which describes how you want your assets to be handled when you die. And a will can be one that's written or it can be one that's prepared by an attorney, but a will is basically you telling your loved ones how you desire your assets to be distributed, either to family members or to a cause. And it also makes it clear instructions on what you would have like to have done with regards to funeral, things of that nature. So a will is very important to have, because if a will is not in place, what you're doing is you're telling the government, you're telling the state to take over and allocate your assets the way they wish them to be allocated. And the unfortunate thing about that is they don't know you, they don't know your family, and they may have things going to people or places that you never would have wanted them to go. So having a will in place is very important. And understand that a will is state specific. So no matter what state you live in, make sure that the will, when you're creating one, is compliant to the laws of that particular state. Also, when you're creating a will, you're basically telling, again, your family what you want to have done with the assets. So it's very important to have those stakeholders, those family members or friends involved in the process. And what I mean by that is once you have written up your will and have your desires on paper, then I highly recommend that you have a reading of the will while your family, while you're living, or while your parents, if you're doing it for your parents, while they're living, in the presence of those individuals that are in the will. So have a reading of the will while you're alive, or the parents are alive, or whoever you're creating the will for is alive, so that there would not be any misunderstanding. Everyone is hearing the wishes of the person creating the will while they are still living. The person creating the will is still living, and can ask any questions or have that discussion if need be. Again, if you are married, obviously you're creating a will for your wife and yourself, and I would recommend that be done at the same time. But also, if you are a child, or maybe you're doing it for your parents, have that talk with your parents. I know it's not easy to have that talk, but a way to make it easy is maybe to talk about other cases, or maybe other situations where you heard people losing a loved one and how that affected their family, and then ask your parents, what are your desires? What are your wishes if something were to happen? How do you want your wishes to be carried out? And that makes the process a little easier and smoother for them to open up to you. Also, I would recommend with a will that you update it at least once a year, or just look over it at least once a year to make sure that it does not need to be updated. You may have moved to another state. You may have gotten married or gotten divorced. You may have children now. Or you may have some of the items in the will may not be in your possession any longer. So make sure that you are updating your will, looking over it, and making sure that everything is up to date. So a will is very important to have in place so that you're making it clear how you want your assets to be distributed and your desires to be carried out when you pass away. Because the thing is, to be unclear is to be unkind. To be unclear is to be unkind. And so have a will in place. Get that done as soon as you can, because life happens, and it does not just happen when a person is old or get older. It can happen at any time. You say, well, I don't have a lot of possessions. Well, it does not matter the amount of possessions. If you have nothing but a picture or nothing but a piece of furniture or maybe a pet or whatever, get a will in place so that your wishes are being carried out the way you desire them to be. The second thing to have in place is a power of attorney. A power of attorney, basically, in a nutshell, is a document where, while you're living, you're giving someone that you trust the permission to carry out your business affairs if you became incapacitated. If you're married, that looks like you have, giving your wife or your husband that permission, or someone else that you trust. Now, this person that you are giving permission to, you want to make sure they're trustworthy, they're dependable, they know how to handle money, they know how to handle business, and again, that they can carry out what you would have or what needs to be done in place of you not being able to do it. So a power of attorney is very important to have. You want to also make sure that you understand that power of attorney is pretty much can be used anywhere, but there's certain governmental agencies that do not accept or do not recognize power of attorney. One being the IRS, another being the Social Security Administration. So when you're engaging those two entities, understand they do not recognize power of attorney. So for instance, with the Social Security Administration, what you would need to do is contact them, and what they would do is have you fill out an application to become what's called a representative payee, where after this application is filled out, you would be the one over the individual's benefits. If they're drawing benefits from Social Security, you'd be placed over their benefits, where the Social Security Administration would engage you. You'll be the one getting the mail. You'll be the one in control of their money. You would also be the one responsible for giving an accounting once a year of how that money's spent. So again, the Social Security Administration and the IRS do not recognize power of attorney, but most other entities do. And again, power of attorney is used for instances if you need to go to the bank to carry out financial transactions, or even any legal business, or just business at large for the individual. So a power of attorney is something that you want to have in place, giving someone that you trust the ability to handle your business for you. And then finally, the healthcare directive, number 3. The healthcare directive is what you would need to have in place in an estate plan. Healthcare directive, again, is another document where you are in the medical arena giving the hospital or a surgeon, if they're about to perform some kind of medical procedure on yourself, your wishes, and you're doing it through a document where you've designated, again, someone you trust to serve as an agent. It can be a family member or a friend, letting them know to tell the doctor or the hospital, if something were to happen while you were there, what your wishes are. For instance, if you were to go to have a procedure done and something goes wrong and you find yourself on life support, you would, through this healthcare directive, be instructing whether or not you want, to be kept on life support or taken off. So again, what that looks like is you would get a person you trust to serve as what's called an agent. And there's normally 2 people that you would choose, for the main agent and then an alternative if that first one is not available or cannot or no longer wishes to serve. So again, this is important because when you go to normally when you go to doctors or hospitals, they ask, do you have a living will, or do you have a healthcare directive? This is what they're asking for, that document to ensure to them what the wishes of the family or your wishes are if something were to happen. And again, this makes it much easier on the family, and it's also, again, you telling your family how much you love them. If you're doing this for another loved one or a parent, understanding that you're setting them up to do that same thing as well. It's very important to have these things in place. Going back to the will, you have what's called an executor, and an executor is one who you're designating to carry out your wishes in the event that you you pass away, basically. So again, let this be a person you trust, the person you know is dependable, can handle business, and will carry it out the way that you wish. So again, the three things you need to have in place in an estate plan is a will, power of attorney, and also a healthcare directive or a living will. Now, this could be done through a state attorney, of course, going through the state attorney. If there's an investment, of course, that you would need to make, it could be a couple of $100 or a couple of $1,000, or there are various sites. One particular site that I want to share is the platform is called Mama Bear Legal Forms. Mama Bear Legal Forms, and you'll find that link in the description, where by clicking on the link, you can create all of these documents yourself in less than 30 minutes. The wonderful thing about these documents, they're written by estate attorneys, and they're state specific, and it walks you through how to create each of these documents in one lump sum. All three can be done in one package in less than 30 minutes, and again at a reasonable price. I'm not an affiliate, but again, I want to share this with you to help you in this very important process of getting an estate plan together. An estate plan is very, very important to have. So I recommend you act now. If you have not done so, act now. If you have one in place and you need some changes, make those changes as well. So, life happens, and, losing a loved one is not easy. So make sure that you have things in place when that happens, especially an estate plan. There's also other things you need to consider when natural disasters happen and things of that nature. Having an emergency kit in place. And I did a video recently on that one as well. Please check out that video where it talks about the different things you would need to have in place to create an emergency kit. And if you don't have those things, there's links in that video where you can order them and to make sure that you have the things necessary in place to have an emergency kit as well for if life were to happen, natural disasters, or lack of access to available resources. But again, tell your family you love them. Let them know that you have your wishes in place, and make the process easier. I'm not going to say it's easy, but make it easier, at least in the process of having the tools and plans in place when transition happens, and that's having an estate plan. If this information was beneficial to you, again, please click the like button, subscribe, and share this video and channel with others that you know would benefit from the content that's found on this channel and in the video. Remember, get that estate plan together today and tell your family through this you love them.